Greetings and salutations, my fellow sovereigns. This is the Vocational Science of Freedom Saturday Night Civics and Sovereignty class, and we are going to be talking about public oaths and public bonds. When they need to be filed, where they need to be filed, how you track them down, what you can do when a public official does not have these things properly filed onto the public record, and all of the remedy that you can bring against them. And there will be two people also talking tonight on their experiences in tracking down bonds and oaths from judges. And the other gentleman will be talking about how he's been acknowledging their oaths on the public record, which then puts them in a very precarious position. Because once you acknowledge something on the public record, you're saying, yes, I have acknowledged that you have an oath to me. And so you'd better uphold it. If you'd like to join the Vocational Science Freedom Gilded server, you can do so by going to gilded.gg/VSOF. And if you want to just click on the link, it's right on the front on the YouTube page. It's also in all of the show notes for all the classes on Rumble and on Odyssey. And you can also find the link on Gab as well at group 30721. All right, so let's start with, to get our bearings here, let's open up VSOF Public Oaths and Bonds vocab. So what I did was I just grabbed the vocabulary words for bond and oath out of Bouvier's Law Dictionary, and let's go over those real quick just so that we know what the hell we're talking about here before we even get going, okay? So a bond, contract, an obligation. Hold on, let me make this a little bit bigger for everyone. You guys probably can't see it yet. Okay. Bond, contract. An obligation or bond is a deed whereby the obligor obligates himself, his heirs, executors, and administrators to pay a certain sum of money to another at a day appointed. If this be all, the bond is called a single one, simplex obligato. But there is generally a condition added that if the obligor pays a smaller sum or does or omits to do some particular act, and that's exactly what we're talking about here for public officials' bonds, that they are bound to do or omit to do some particular act, in this case to uphold the Constitution for the United States of America and the state of which they are operating within. And I think some states actually have some other things that go along with what they are bonded to do or not to do as well. But this will be a continuation of our investigation into everything about public bonds. But to continue here, okay, so if the obligor pays a smaller sum, does not, or omits to do some particular act, the obligation shall be void. The word bond, XV timenti, imports a sealed instrument, okay. Condition, interest of money, penalty. It is proposed to consider, 1, the form of a bond, namely the words by which it may be made, and the ceremonies required. 2, the condition. 3, the performance or discharge. So 2, there must be parties to a bond, an obligor and an obligee, for where a bond was made with condition that the obligor shall pay 20 pounds to such person or persons as EH should by his last will and testament in writing, name and appoint the same to be paid, and EH did not appoint any person to or whom the same should be paid. It was held that the money was not payable to the executors of EH. Okay, so there does have to be some it seems as though right off the bat there is some specificity regarding bond construction, which we should also figure out and learn, because I bet there'll be some point where these public officials might be filing bonds and we might look at it, but it might not even be an officially correct bond. That wouldn't surprise me either if they were doing that, just to get out of their obligation. So we're going to have to know exactly how to write these things and what they mean, and probably have to get as many examples as we possibly can. And as a side note, everything that we'll be wanting to collect on this matter, we will be wanting to put into two separate categories two separate committees within the VSOF, and that'd be bonds and bonding, and then controlling public trustees right here, So the oaths and everything to do with oaths will go here, and the bonds will go here, but feel free to copy anything from one to the other when dealing with this sort of situation, okay? So, but that's where we're going to do the work, and I'll make sure that I copy and paste everything that I have. I didn't have a chance to go through everything on my computer tonight yet for regarding this issue, but I will get it into those two committees within the next few days, because I'm really interested in this, and I'm really interested in what Viper and Emery have been up to. So number 3, must be in writing on a paper or parchment, and if it be made on other materials, it is void. Okay. It must be sealed. Oh, it must be sealed. Okay. Though it is not necessary that it should be mentioned in the writing that it is sealed. Okay. As to what is sufficient sealing, see the above case in the word seal. The above case. Oh, it must be here. 5, it must be delivered to the party whose bond it is, to the other. Okay, so that would be recording it onto the public record. But the delivery and acceptance may be by attorney. Okay, fine. The date is not considered of the substance of the deed, and therefore a bond which either has no date or an impossible one is still good. Okay, provided the real day of its being dated or given that is delivered can be proved, right? Because that'd be full force and effect. 6, the condition is either for the payment of money or for the performance of something else. In the latter case, if the condition be against some rule of law, merely positively impossible at the time of making it, uncertain or insensible, the condition alone is void, and the bond shall stand single and unconditional. For it is the folly of the obligor to enter into such an obligation from which he can never be released. Yeah, good point. If it be to do a thing malium in C, the obligation itself is void, the whole contract being unlawful. Okay, that's logical. That's the same way the contracts would be. 7, when the condition of an obligor or the act to be done of the obligee is of its own nature transitory, as payment of money, delivery of charters, or the like, and no time is limited, it ought to be performed in convenient time. Okay, fine. 8, a payment before the day is good or before action brought. Okay. 9, if the condition be to do a thing within a certain time, it may be performed the last, that should be day of appointment. That was a misgrab, I'm sure, by the original transferring here. Number 10, if the condition be enacted without limiting any time, he who has the benefit may do it at what time he pleases. Okay, fine. When the place where the act is performed is agreed, the party who is to perform it is not obligated to seek the opposite party elsewhere, nor is he to whom it is performed bound to accept the performance in another place. Okay. From what amounts to a breach of condition in a bond, see conditions. Okay. All right. So that's what a bond is. And again, what we're going to be worried about regarding public officials' bonds are going to be this aspect of that they shall have an obligation to do or not to do some particular act. That's the whole point of the public bonds. Okay, so now let's go to oath. Oath, a declaration made according to law before a competent tribunal or officer to tell the truth, or it is the act of one who, when lawfully required to tell the truth, takes God to witness that what he says is true. It is a religious act by which the party involves God not only to witness the truth and sincerity of his promise, but also to avenge his imposture or violated faith, or in other words, to punish his perjury if he shall be guilty of it. Well, then, if it's always a religious act, that would make perfect sense why no Luciferian would ever file a public oath. So that makes sense off the bat. Okay. Number 2, it is proper to distinguish two things in oaths. 1, the invocation by which the God of truth, who knows all things, is taken to witness. 2, the imprecation. I don't know if I know that word. The imprecation by which he is asked as a just and all-powerful being to punish perjury. Okay. 3, the commencement of an oath is made by the party taking hold of the book after being required by the officer to do so, and ends generally with the words, "So help you God," and kissing the book, where the form is used, that of swearing on the evangelists. Number 4, oaths are taken in various forms. The most usual is upon the gospel by taking the book in the hand. The words commonly used are, "Do you swear that," etc., etc., "So help you God." Then kissing the book. I did not know that kissing the book was a thing here, but okay. The origin of this oath may be traced to Roman law. Well, that's odd. Okay. And the kissing the book is said to be an imitation of the priest kissing the ritual as a sign of reverence before he reads it to the people. Number 5, another form is by the witness or party promising holding up his right hand while the officer repeats to him, "Do you swear by Almighty God, the searcher of hearts, that," etc., and this as you shall answer to God at the great day. Never heard that one, but that's certainly more formal. I'd like to hear that one put up in court sometime. Number 6, in another form or attestation commonly called an affirmation, which is what we usually run into nowadays. You don't really have these like more religious oaths. Again, obviously, because the vast majority of the people that would be having to take them are all Luciferians anyway. So you usually have, "Do you solemnly, sincerely, and truly declare and affirm that," etc., etc. But those, even an attestation or called an affirmation, those are still under penalty of perjury as well. So you're still basically saying, look, if I'm lying or if I don't do X, then you can hold me in contempt or hold me for perjury. It's more or less what you're saying. Number 7, the oath, however, may be varied in any other form in order to conform to the religious opinions of the person who takes it. Okay, that makes sense. 8, oaths may be conveniently divided into promissory, assertory, like to assert. I might not be pronouncing that right. Asserted. I want to say assertatory, but that doesn't. I guess it's just assertory. Assertory, yeah, I guess. Judicial and assertory. Okay, thank you. Judicial and extrajudicial. Okay, so oaths may be okay. So these are the only types of oaths there are: promissory, assertory, judicial, and extrajudicial. Okay. That will probably be important for us to remember as we're going forward here. Among promissory oaths may be classed all those kinds. Oh, okay, so we got the answer. Okay, among promissory oaths may be classed all those taken by public officers on entering into office to support the Constitution of the United States and perform the duties of the office. So all of the oaths we're going to be looking for are going to be promissory. Promise to do X. All right, so that's going to be important. All right.
Number 10. What did you say? Commissary? What was that?
Promissory. If you want to just open up, you can read right along. It's the VSOF Public Oaths and Bonds document, but I can just grab this real quick and just throw it in the chat. That's what I'm reading from right now, so anybody can just follow along. But it says oaths may be conveniently divided into promissory, assertory, judicial, and extrajudicial. Among promissory oaths may be classed all those taken by public officers on entering into office to support the Constitution of the United States and to perform the duties of the office. So all the oaths that we're going to be looking for are going to be all promissory.
So this raises a quick question. Sorry to interrupt.
No,
you're pulling this out of Webster's dictionary. Is there a different definition in Bouvier's or Black's?
No, I'm reading from Bouvier's. Amaru just dropped it from Webster's.
Oh, okay. Thank you.
The oaths and the bond definitions that I have in here are both from Bouvier. So, all right. Number 10, custom house oaths and others require by law not in judicial proceedings, nor from officers entering into office may be classed among the assertory oaths when the party merely asserts the fact to be true. Right. Okay. So that's what an assertory oath is. I just assert that I swear to seeing Joe shoot John, whatever. 11, judicial oaths or those administered in judicial proceedings. Okay, that must be like, I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. Extrajudicial oaths are those taken without authority of law, which, though binding in foro constantia, do not render the persons who take them liable to the punishment of perjury when false. Okay. 13, oaths are also divided into various kinds with reference to purposes of which they are applied as oaths of allegiance, oaths of calumny, another one that got me tonight, oath ad litem, dissitory oath, oath of supremacy, and the like, as to the persons authorized to administer oaths. Okay. Act of Congress, June 1st, 1789, regulates the time and manner of administering certain oaths as follows. Subsection 1, be it enacted, etc., that the oath and affirmation required by the 6th article of the Constitution of the United States shall be administered in the form following, to wit, I, A.B., do solemnly swear or affirm, as the case may be, that I will support the Constitution of the United States, close quote. The said oath or affirmation shall be administered within 3 days after the passing of this act by any one member of the Senate to the President of the Senate, and by him to all the members, and to the Secretary, and by the Speaker of the House of the Representatives, to all the members who have not taken a similar oath by virtue of a particular resolution of the said House, and to the clerk, semicolon, and in cases of the absence of any member from the service of either House at the time prescribed for taking the oath of said affirmation, the same shall be administered to such member when he shall appear to take his seat. This is all way back in the days when they weren't always constantly there. Subsection 2 of this. Okay, well, this is just constitutional aspect. I don't think I really need to read this because this is more based on federal personnel, and we're going to be dealing pretty much most of all the time with state, unless of course you are in federal court, I suppose. First session of Congress and every general session election of representatives, the oath or affirmation aforesaid shall be administered by any one member of the House of Representatives to the Speaker. Okay, blah, blah, same thing. That the member of the several state legislatures at the next session of the said legislatures respectively, and all executive and judicial officers of the several states who have been heretofore chosen or appointed, or who shall be chosen or appointed before the first day of August next, and who shall then be in office, shall within 1 month thereafter take the same oath or affirmation, except where they shall have taken it before, which may be administered by any person authorized by the law of the state in which such office shall be holden to administer oaths. And the members of the several state legislatures and all executive and judicial officers of the several states who shall be chosen or appointed after the said first day of August shall, before they proceed to execute their duties of their respective offices, take the foregoing oath or affirmation, which shall be administered by the person or persons who, by the law of the state, shall be authorized to administer the oath of office, and the person or persons so administering the oath, hereby required to be taken, shall cause a record or certificate thereof to be made, in the same manner as, by the law of the state, he or they shall be directed to record or certify the oath of office. Okay. So this will apply then. So let's make sure that we track down a copy of the Act of Congress of June 1st, 1789. I guess it's in Stories, page 1. Regulates the time and manner for administering oaths. And then it's this subsection 3, that all the state officers have to follow, which makes sense because they're going to have to. But this is very interesting, actually, because I never knew where this actually was, truth be told. Why or where the place was where the state officers had to swear an oath to the federal Constitution. But I just got my answer, and it is in that act. So, okay, cool. All right. Good. And, right, 17, subsection 4, that all officers appointed are hereby to be appointed under the authority of the United States shall, before they act in their respective offices, take the same oath or affirmation, which shall be administered by the person or persons who shall be authorized by law to administer such officers their respective oaths of office, and such officers shall incur the same penalties in case of failure. Shall incur the same penalties in case of failure. Right. We got to figure out all of what shall be incurred in cases of penalty of failure, because that's the problem, because none of them seem to fucking have them. As shall be imposed by law in cases of failure in taking their respective oaths of office. Okay. So there's got to be state law for that, clearly. There'll be state statutes for that. I don't know, or we'd have to track down where. I wonder if there's a USC that you could hold against state officers who didn't take the oath as per this subsection 3 of this act. And I bet you anything there is. We just have to track it down. Okay. So that's a homework assignment we can do later. All right, subsection 5, Secretary of the Senate and the Clerk of the House of Representatives, that's a misprint, representatives, for the time being shall, at the time of taking the oath or affirmation aforesaid, each take an oath or affirmation in the words following to wit, I, A.B., Secretary of the Senate or Clerk of the House of Representatives, as the case may be, of the United States of America, do solemnly swear or affirm that I will truthfully and faithfully discharge the duties of my said office to the best of my knowledge and abilities. Close quote. And that's pretty much what I've seen all the state ones more or less say, whatever it is. 19, there are several kinds of oaths, some which are enumerated by law, right? Oath of calumny, I guess. This term is used in I'm going to say Roman civil law. This is an oath which the plaintiff was obliged to take that he was not actuated by a spirit of chicanery in commencing his action. What the fuck? Okay. But he had a bona fide of good cause for the action. This oath is somewhat similar to our affidavit of cause of action. Oh, fascinating. Okay. This weird stuff like this in the history of law is the shit I love to find. Because, like, I didn't know where, an affidavit of good cause would have come from as far as the history of it goes, but here you go. Not actuated by a spirit of chicanery in commencing his actions. Okay. 21. No instance is known by which an oath of calumny has been adopted in practice in the Admiralty Courts of the United States, fine, and by the 102nd of the rules of the District Court of the Southern District of New York, the oath of calumny shall not be required of any party in a stage of cause, fine. Declaratory oath. Okay, so these are all the different kinds of oaths. Let me see if I skip down here. If anything, a judicial oath is solemn declaration made in some form warranted by law before a court of justice or some official officer administered by it, which by the person takes the promise to tell the truth. Okay, yeah. That's a judicial oath. So this is the one that you take on the stand, or that all witnesses have to take on the stand. In civil law, judicial oath is that which is given in judgment by one party to another. Okay. Oath in litem. Okay, we don't need to get into this. Promissory oath is an oath taken by authority of law by which the party declares that he will fulfill certain duties therein mentioned as the oath which an alien takes on becoming naturalized, that he will support the Constitution of the United States, the oath which a judge takes that he will perform the duties of his office. The breach of this does not involve a party in the legal crime or punishment of perjury, but it sure as fuck does create a legal crime of impersonating a public official. So that we can certainly get him for. I'm going to put that one in check because that's the one we're looking for. So we're looking for these promissory oaths. Supplementary oath in the civil and ecclesiastical law is an oath required by... Wait, what? Is an oath required by the judge from either party in a cause upon half proof already made, which being joined to half proof supplies the evidence required to enable the judge to pass upon the verdict. Interesting. Wow. I wonder if that's what arraignment is. Anyway, sorry, don't want to digress here. Number 30. A purgatory oath is one by which one destroys the presumptions which were against him, for he is then said to purge himself when he removes the suspicions which were against him, as when a man is in contempt for not attending court as a witness, he may purge himself of the contempt by swearing to the fact, which was an ample excuse. Okay, fine. All right, so got those locked down, at least a good general understanding of what these two things are that we're looking for, and what we need to hold them to as far as that's concerned. I'm going to cover this real quick too, blow this up. This was just a little document that I found in kind of bouncing around my computer tonight looking for oaths and bond stuff. Don't know where I got this. Looks like something that just somebody wrote really quickly, but at least it's about how to track down bonds in Texas. So report corrupt officials to the state insurance board and request bond info and oaths from state comptroller, not Secretary of State. And so this at least in Texas, you go to the state comptroller to go find their oaths. And these are going to be different. Where to go find the bloody thing is going to be different in every single state because they're different laws, different constitutions, different places. There's even different offices where things are recorded. So in one state, you might have a county recorder, and in another state, it might be called something entirely different. It might not be called a county recorder. It might be called something else. It might and the oaths and bonds might have to be recorded into the county court, or in Texas, they have to go to the comptroller. So all officials are required by federal, state, and municipal law to provide the name, address, and telephone number of their public hazard and malpractice bonding company and the policy number of the bond when requested, and if required, a copy of the policy describing the bonding coverage of their specific job performance. Failure to provide this information constitutes corporate and limited liability. Here it is in Texas State Code. Under, well, I'm not going to read all the code, but I'll just try and get to, okay. Filing of official bond. An officer required by law to give an official bond shall, that's not an option, file the bond with the officer's oath of office. Okay, so in Texas, they have to be put them together. Sureties, an officer shall execute the officer's official bond with 1, 2 or more good and sufficient sureties, or 2, a solvent surety company authorized to do business in the state. Okay, so this is where they're going to be.
Hey, Zen, can I interrupt real quick?
Yeah, go ahead.
Can we have one of your sections on Gilded, I guess, in the state assemblies or whatever, specifically breaking down each state's the section you're talking about right now, so we can categorize this?
Anybody that's in their own states needs to go and put it into their archives. So yeah, anything that you're going to do in the state assemblies, in the one assembly that you should follow of what it looks like is Florida's, because LG did a really good job in doing the categories for the state archives for Florida. And the state in Florida archives, everybody can look at. But yes, for your state, and by the way, if you don't see a state assembly in your state assembly section, then that means there's not at least 10 people from your state there. Unless you pick your state roll properly, you won't be able to see your state assembly room. But say so for Florida, yeah, Viper, you'll be able to, I would put in here, create a topic, say, call it Florida bonding, Florida public official bonding, or something like that. Whatever you want to create for the archive topic. And then yeah, feel free to track it down the same way it says here in Texas. Drop the links.
Yeah, I'm still trying to find it.
Well, let's take a look at what this thing says. Okay, so it's under Chapter 6, Public Officers and Employees, Subtitle A, Provisions Generally Applicable to Public Officers and Employees. Chapter 606, Official Bonds, Section 604.001, Filing of Official Bond. So I would suggest, in tracking it down in the state statutes, to look for the sections of state statutes regarding public officials and their duties. Sometimes you'll find that in what's called the government code, like in anybody listening in California, you'll find this type of shit under what's called the government code, which obviously in Texas it says too. It says government code. So always start there first if there is one, and start tracking it down. And then I said, and this is just his writing, whoever he is, the public education system teaches us almost nothing compared to what is essential to navigate through life. Anyone who's blatantly been denied due process or had constitutional rights violated by police sergeants, county clerks, public prosecutor, judges, and every other form of attorney can report the matter to the Texas Insurance Board. Usually that public official's bond will be suspended until the state does an investigation. Okay, that's interesting. So take a look in your states and see if they have a Florida Insurance Board, a Pennsylvania Insurance Board, and see what the process might be for that, because at least for Texas, that's how that looks like that plays out. Usually the public officials, okay, and an investigation this way, you do not have to spend your own resources to get remedy. In fact, you can file a Freedom of Information Act on the county and ask them for their oaths and bonding information. If they deny you, then you report he or she to the Texas Insurance Board. This way, you prove that they are denying your request, hiding information, bullying, and sending a FOIA request to the state comptroller with a copy of the denial letter or email. If the public official claims that they do not know what you're talking about, oh yeah, here's the code, biatch, Texas, in Texas anyway, Texas Insurance Code, suit on certain bonds or other obligations, venue of suit of certain bonds and other obligations. This section applies to a bond or other obligation of an insurance company authorized to engage in business in the state to act as surety and guarantor on the fidelity of employees. Okay, great. Trustees, executors, administrators, guardians, or other appointed to or assimilating the performance of any public or private trust. Oh. Any public or private trust under appointment of a court or tribunal. That'd be every single fucking court case. Oh, this might get way more interesting than I thought if that's the situation. Okay, anyway, I'll think about that later. Or under contract between private individuals and corporations. 2, a bond that may be required to be filed in judicial proceedings to guarantee a contract or undertaking between yada, yada, yada. Or C, of a state, county, municipal, or district official, including a school district official. B, a proper court in the county in which a bond or other obligation described by subsection A is filed as jurisdiction of the suit instituted on the bond or obligation. Okay, so you can send a Freedom of Information Act, and again, this is Texas, request to the Texas Comptroller, like it says in the code, and request the specific official's oath according to these codes. Their oaths are on file at Texas State Comptroller's office, not the Secretary of State. Okay, blah, 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 bam, bam, bam. Okay, cool. Okay, so that's that. And that's actually a pretty good segue, Vipe, if you want to just go ahead and start telling everybody what you recently did. And if anybody wants to see kind of the information, we more or less had a conversation about it in main chat today. Viper actually dropped his letter, which I'll open up here and have it open on my screen. If you want to tell everybody what precipitated this, you go ahead and start telling your story of what this even is and why you did it and what's going on.
All right, so I got to give a pretext to this, just a quick background. I got picked up and tossed in the clank for one night for refusing to produce my ID, because I know that they're not bonded, they're not oathed and nothing, and he basically kidnapped me and put me in jail. Fast forward to recently, okay, I learned through different studies that none of these judges, none of these public officials have a valid oath of office. And this is a segue, a caveat, Zen, for the information you're talking about. But for judges, they have to. This is not an option. They must, by federal law, take an oath under Public Law 1 Statute 23. This is critical. It doesn't matter if it's a municipal. If you're going to wear the title of judge, you must have that oath. Okay.
Yeah, that's what that federal act was right here. The Act of Congress, June 1, 1789. It actually says there that's what they got to do. So it must connect in with that. Now, if you've got the statute for Florida, yes, definitely put it into the Florida archives. And anybody else that finds or tracks down exactly where the statute is, that like the same one that Viper's talking about, pertaining to your state, instead of Florida.
No, this is public law. So the states, the judges that operate at whatever level, it's universal. There's one oath across the country.
Which apparently comes from this act of Congress that I was just reading about. Okay, cool.
That's exactly it. So whether you're whatever level, you have to take this. And this is the lawsuit that I've actually got going on right now in Florida. So I go through my case and I'm trying to get my doc set mature and all this other stuff. And I learn about this whole oath thing. We filed a lawsuit. It was more than just a lawsuit, but basically the lawsuit is essentially you don't have a public oath of office, so you're violating public law. And in so doing, you've also usurped the bench of a judge. You're impersonating a judge. 12 million each count. Okay. Yeah. First day, first judge gets it. He's like, I'm out of here. Recuses himself. It's been 8 weeks. Nobody's touching it. Anyway, so what does this mean? What does this have to do with the letter that's on your screen? Okay. We filed a lawsuit. Judge left. Now, the court case that I'm dealing with is a county court. Okay. A criminal justice center for the county. And the state comes in as the prosecutor. Okay. Obviously, there's no witness and nothing. It's all about probate fraud. We already know that. So what am I talking about here? Okay, so in the process of discovery, I'm talking with somebody else. He's like, hey, "Do you think I should get so and so's oath of office?" It's like, "Yeah, go for it." So the people that are defending the judges. I say that plurally because at this point I have two. The people that are defending the judges come from the state.
That's the assistant state attorney, right?
The assistant state attorney general.
Right here. The one that doesn't have the oath, as per your FOIA request, is the one that's defending the judges that you're suing.
Yes. This is the guy, Leiden. He is he's basically Ashley Moody is the state attorney general who I process served with the KW and the state docs. He is her assistant. So he is her minion. Basically, he is the assistant state attorney general. And he comes in with a motion to dismiss, and he only addresses the oath. He doesn't address the other two issues, thinking that if I just kill the one, it's going to kill the others, and it doesn't. Because if they do not have a valid public oath of office, they forego, meaning they don't have any standing for immunity, which is what they rely on. It's like they're wanting to have their cake and eat it too. No. You never had an oath to begin with, and that's the whole point. So if they never had an oath, they have no standing whatsoever to issue any orders, to do any of the shit that they're doing, let alone put people in prison. Okay.
Exactly.
Or in jail or whatever, because it's all probate fraud. The living person is not the fucking defendant. Anyway, so I send off to the Secretary of State, because all this time I've requested all of the county judges in the criminal division to get a copy of their oath. I've got two of the certified, and then the rest in the county. And so I send off to get this Attorney General, and this is the letter back from the Secretary of State for Florida saying, we have no record of this person that you're looking for. He doesn't have an oath, and he's in a public official office. So he's totally breaking the law. He's not even in any official capacity, and he's coming in and trying to defend two different judges without a valid oath of office himself. So he's in a lot of trouble. So that's the story behind it. Like this Muppet from the state comes in thinking I'm a hot shit. No, he has no authority whatsoever to be doing anything, let alone coming in and trying to defend these judges. So that's where this letter came in. This was a response to my request for Leiden's oath of office, because he's trying to defend these two imposters, and he's subservient to Ashley Moody.
Okay, so the question is, did you already know that this guy, the assistant, Lyndon, did you already know that he did not have an official oath of office, or did you actually find that out by this FOIA request?
I did not know that he did not have a oath of office.
Okay.
This was a conversation that I had with somebody else, where it was just basically, hey, seeing as how we're dealing with oaths and these judges don't have it, what about these attorneys? They're public officers. Let's go dig that up. So I'm glad I did. And it took him like almost 3 weeks to do it. Like, we can't give it to you. So yeah, they don't have any public oath of office because they can't take the valid oath, because there's a conflict between the fact that these are done in Bradstreet corporations. They each have their UEI numbers, and they're done in Bradstreet numbers.
There's also the CRIS system too, and there's also the IOLTA account. So IOLTA is an acronym, stands for Interest on Lawyers' Trust Accounts. And what attorneys do is they trade cases between each other, because during the life of a case builds interest. And all of this is the back. What Viper and I are talking about right now is all the backside of the financial aspect of what these private for-profit courts are doing. No one has to really lock all that down except for people like us who are going to totally end the system. But just know in general that there is a lot of securities being created, and billions of dollars in securities being created through these court systems, and via these means of the attorneys being able to move them around in the CRIS system, in the IOLTA trusts, and through these private for-profit courts. Okay, so just know that that's what's going on, and I completely agree with Viper that it is absolutely like a catch-22. They can't actually go and swear an oath, because if they did, they'd instantaneously be breaking it at the same time by doing what they're doing. So it's a strange thing, and it's actually kind of beautiful that they've wrapped themselves up in a nice little basket of gifts and say, here, do whatever you want to us, because everything we're doing is unlawful, which is great. I think that's a good day. And we can do everything that we want to, from writs of Quo Warranto to the state Supreme Court to say, get out of here, which means you could boot judges. You can also easily boot this assistant to the state attorney general, this Schultz guy, boot him. And as I told you earlier today at Over Mega, I said, or maybe it was yesterday, but anyway, if Schultz is the only guy on the judge's cases as the only attorney of record for both of them, every single thing that this moron has ever filed into those cases, including the motion to dismiss, all of it has to be removed from the record. Because if he never had valid office, he couldn't possibly have been the lawful attorney of record for the case. And so everything, every motion, every pleading, anything he's ever said or done has to be removed from that case. And you can go directly to the clerk of the court and find out if this guy is the attorney of record. And then you can present this notice, or this FOIA, I should say, to the clerk and say, I demand that all of this man's filings be removed from this court case because he never had any official authority to file them in the first place. And the clerk should, if they understand law, they should obey you, and they should remove everything. So then the judges would be ass out. They'd have to go find some other idiot to go defend them. And if Ashley Moody does actually have an oath, I bet you she won't touch it with a 10-foot cattle prod. So who knows who they might end up getting, but I would do that with this letter to attack the idiot, the Schultz, to get rid of anything that he's filed onto the court case. So, okay, cool. So I wanted Amaru to make sure that he had a chance to talk about everything that he's been doing in Colorado as far as grabbing the oaths as well, and have him explain what he's been doing out in Colorado.
The only oaths that I've verified as of up to now are the oaths of a deputy and the sheriff, and then a former sheriff and the current judge. So when it was about 2 years ago or so, 2.5 years ago, I'd gotten a traffic ticket for no license by the sheriff and the deputy here. And it was a $35 ticket for no license. The sheriff told me it was like he had written a ticket for someone who had never gotten a license, like a teenager. And mind you, I don't have a driver's license at all. And all I gave him basically was my passport. And he wrote me that ticket. And then I went down to verify that they had oaths, and I saw that they did. So I created a document that was an acknowledgement and acceptance of their oath of office. And then I basically gave them a notice of intent that if they failed to perform accordingly, I was going to hold them accountable. And honestly, I haven't been bothered by them since. But after verifying that oath, there was a deputy, I should say, who was our previous sheriff, and he retired for a couple years, and then they needed some more people here, especially in the summer. We get really busy in the summer, so they got him back on, and he was kind of messing around with the locals a little bit, and one of the locals was my friends, and that he was bothering. So I went down to the county clerk's office and hopped on the computer, punched in his name, punched in oath, and then hit search, and there was his oath for when he was sheriff, but no oath for him currently as deputy. And I said, oh, that's a big no-no. And I even said to the county clerk, I'm like, hey, I see here so-and-so doesn't have an oath. And she actually was like, yeah, he never came and gave one to me. And because she's the one who he's supposed to give the oath. She's the one who administers the oath and then records the document.
So in Colorado, it's the county clerk then? Is that what it is?
Yeah, they administer the oaths to the county clerk. And the one done by the judge here, that's for the sheriff and the deputies. They do it to the county clerk. She's the one who administers the oath. And then our county clerk, the county clerk of court is the one who administers the oath for the judge.
Okay.
And I just recently got the one for the judge, but very interestingly, okay, I guess I should finish my story first with the deputy. So I told him that, and then the next day he was down there administering his oath.
Okay. Interesting.
Yeah, the very next day he put one. He went and did one that day and put it on record. So he did that before we came after him, and really they didn't really bother us anymore after that. But I just recently, as of yesterday, Friday, went and got the oath of office for our judge, and I'm going to work on doing an acknowledgement and acceptance of his oath too, and have that served on him. And I do believe I'm going to do it under seal. That way, it's a covenant.
Right, exactly, and you're acknowledging it as one of the people, which then clearly delineates the relationship between you
Exactly.
and them. And that's what's most important, is that we have to get back on top in our proper sovereign capacity above them.
Did I hear you correctly when you said you're creating a compact, or what was that?
He's creating it. He's creating an acknowledgement and an acceptance. When he gets done with it, I'm going to go through it and we'll work back and forth, and we can have an editing session, all of us, and finish it up.
Covenant. It's a covenant.
Yeah. A covenant is a covenant. A covenant is any contract under seal. That's a covenant. Okay. So when he signs and seals the acknowledgement and acceptance of the oath, it becomes a covenant to them. Get it?
Yeah, that's my intent, and then also my intent is to hold them accountable, and also if they screw up, and also it is under the seal of the court. So in some way, it is a covenant in that way too.
Exactly right, because then it gets filed as that, and then get a certified copy of that. Then technically, the court should put its seal on it as well.
Yeah, it has the county seal because it's certified, and then it has the court seal, which is the county and district court seal on it as well. And then I intend on adding my seal to the mix too.
Okay, good. Yeah.
That's absolutely amazing. That's pretty good. I like that.
See, but that only works for people that actually have their oaths. So if they have their oaths, you do it the way he's doing it in Colorado. You acknowledge the oath, put it through, create it into a covenant, lock them in, and say, all right, your ass is mine now. And then for the ones that don't have oaths, well, then you do what Viper's doing and you take them to task. Either way, you win.
Ask, is the oaths that you found, are they in compliance with public law, or are they these fake oaths?
So it's not exactly. It's a very short oath. I don't think it's really full. I can read it out to you. It says, I, so-and-so, do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of Colorado, and will faithfully perform the duty of county judge, the position to which I'm about to enter. And then it has his name signed, subscribed, and sworn or affirmed before me on January. And that's another interesting point I wanted to point out.
Well, that does sound right. Correct. To me, that sounds correct.
Yeah, it's pretty short. But yeah, I mean, it doesn't say anything about God.
No, it's actually that's not the actual lawful oath under Public Law 1 Stat 23, because it doesn't talk about any states. Because what they're trying to do in each of these states is circumvent the supremacy clause, and that's the whole main point of the lawsuit that I'm filing. Is that you don't get it? You don't, just because you're in a different state, you don't get to get around this. Everybody has to be uniform across the country. So that's why it's so powerful for what we're doing.
Yeah, according to that,
I don't want to detract you.
Yeah, according to that act that I found, just reading the definition in Bouvier's, as far as that's concerned, yeah, that does seem to be the case. And it was laid down in 1789 that the members of the several state legislatures, the next session is, blah blah blah, they have to take this, and all executive judicial officers of the several states who shall be chosen or appointed after the said date shall, before they proceed to execute the duties of their respective offices, take the aforegoing oath or affirmation. So yeah, that's where it comes from. That has to be in there. Question is, would have to track this down and make sure that the verbiage is correct, which is what you're getting at, Viper, that it's not correct because...
Exactly.
Okay. So, all right.
Yeah.
So it's got to follow it. Huh?
So regarding the judge's oath, he took office in 2020, and his oath just got put in 2023. He just got his oath on record. So he was holding office for 3 years almost without an oath. And mind you, I actually was having proceedings before him during that time. And it was around the same time that I got on to that ex-sheriff, the deputy, about not having his oath. So I do believe that he must have done his as well sometime around that time. I just realized that.
Well, if they would have gone after you for anything and, given you a fine or whatnot, then that can be removed because he wasn't properly holding office at the time.
Yeah, it wasn't him who wrote me the ticket, and the ones who did write the ticket, they had valid oaths, but it doesn't. I mean, I did charge just.
Yeah. Okay. Cool. No, good. All right. Cool. Okay. Awesome. That's a really good introduction, guys. Thank you both for your stories and what you've been up to. And obviously, this goes along for everyone. We will be continuing to keep up with everybody here regarding what they're doing for oaths and bonds. We will also make sure to put all the oath and bond information in the correct VSOF committee rooms, as I stated before. And when Amaru gets done with his template, then we'll make a template for everyone where you'll be able to change out the name of the state, the name of the public official, your name and address, and then we'll make sure to put it up onto the server so that everybody can start going ahead and getting the oaths that are actually properly filed onto the public record and start acknowledging them to seriously put them under the bus, because then if they violate that oath, and then they're literally committing treason against the state or the United States as a whole, whatever the case may be. So thank you, gentlemen, again. I don't think there was anything else I wanted to cover. I did. Yeah, Viper, go ahead first, and then Amur, go ahead.
Real quick, something was brought to my attention, and this is a personal experience that I've had related to all this, because we've got multiple types of bonds. This has been a really major confusion factor, and maybe we don't have to talk about it tonight. Maybe you can put it on for a future talk, because when we're talking about bonds, we've got the bonds that get people out of jail. That we've got the bonds that are public oath requirements, or the public law requirements for public officials.
Yep.
And then we have the secret GSA bonds that are being used to trade with.
Yep.
And even though I have personally filed a public records request on these things, the language, and this is a manipulative trick that they use, and we need to discuss it and break it down further, is when I'm doing an open records request, which they don't respond to and they won't ever answer, trying to track these bonds down. And even I've even gone to a bail bondsman to try and get certain specific information. They protect this information like it's solid gold.
You cannot go to a bond company and just start demanding stuff as far as like information goes. You have to have the bonding information. Now, when Drew did it in Colorado, he got them to produce the bonding information. So I have templates for how to demand it. Now, it didn't work for you in Florida, but obviously you saw the evidence of what it does look like when it does work. And so people are going to have to start knocking on the doors and start getting their feet wet and starting to learn how to swim here and going after and trying to pull as much of the information as they can for those case bonds. Because once you have the case bond information, then you can contact the bonding company and say, hey, you guys have a bond that's in my name. I need to have it canceled. And once you cancel it, it cancels the case. But yes, they're going to protect that like gold, because guess what? If we all started doing that, there wouldn't be any cases, because none of them would ever continue, because they would be under their personal full commercial liability, which of course they're not ever going to do. They're not that stupid. So yeah. So, all right. Amber, what did you like to say? And then I think we'll close up with that, whatever you have for your last comment.
Okay, so in regarding the acknowledgement and acceptance of oath of office, I was considering putting in there that the 13th, the original 13th Amendment, because I really think that would throw them for a loop. And obviously, if you really look into it, it was properly ratified, so it technically is still law. So I was just wanting to see what your perspective on that would be.
Yeah, if it's there from legitimacy, it needs to be done correctly. I mean, here's the thing. If it's public, and this is kind of like what Mr. Manifest just put into chat, this is the problem. So you have public law that requires they do X, like as in the Judiciary Act of 1789, the one I was just reading from, of which Viper was talking about, that has to be uniform across all the states. Then you have the corporate states coming in and changing things through statute, which is public policy, not public law. And as Mr. Manifest wrote, he said that he sent off for North Carolina Administrative Court, Office of the Court. Good morning. Thank you for your public records request as of July 13th, 2023, pursuant to section la. Clerks of court are no longer required to have bonds. Oaths of office can be found at clerks of Superior Court of the county and district where the court was elected. The clerk may charge a fee for a copy of the oath, la. Okay, well, if they're changing anything like this that is the opposite or goes against public law, as in like the judge's oaths and what we were just reading, then the public law supersedes. It's not the public policy that will control, it's the public law. They just are hoping that you're too stupid to go find the public law. That's what they're really betting on here. And it's a bad bet when it comes to people like us. It comes to the general population, okay, fine, most people don't even know anything about these matters. But when you have a group of determined men that know how to look things up, well, sorry, you're not going to be able to hide very long, clearly. So that's my take on that. So make sure that you find the public law for your state, and I think it'd be a good idea to put into the template that we'll use for the acknowledgement of the oaths, but I think it might also be a good idea to create a template for a notice of understanding and intent regarding judges, and stating, hey, you need to have the oath, and if you don't have the oath, this is what I'm going to do to you, with you, against you, whatever, if this oath is not produced and or your bond produced, right? So I think we should have a template for that kind of notice of understanding and intent regarding oaths and bonds for public officials, both state and federal. And I'll try and make a template in a way that will be as generic as possible so that anybody can put in their information and it will still be applicable, because it will be based upon public law that all of them have to follow. So that sounds good. We've come up to the hour. I think we had a really good session here, and I think this is a continuation for further inquiry. And if anybody'd like to join and help out in the committees, you're welcome to do so. Just go check out what the committees are, start tracking down this information and start looking it up, and then just drop it into the correct committee. And if you're not sure where something needs to go, then just go ahead and put it in the chat area. If you are responding to an aspect of a post in one of the forum rooms, you can do that. You can add on to, you can just click onto, so web links for this topic regards bonds and bonding. If you found a web link that has important information to law, go ahead and put it in here. And then the whole committee can use it when we create documents and other notices that will go out to these people that are not doing what they're supposed to be doing. So with that, I'd like to thank you all for coming. This has been the Vocational Science of Freedom Saturday night Civics and Sovereignty class. And I hope all of you enjoy the rest of your weekend. And until next time, as always, stay safe and stay sovereign.